Thank you, Mr. Chairman, members of the committee. First, our short title, a little less inflammatory, attorney fees, city or county action outside of authority. The primary change is that we are using the language where it's outside the scope of legal authority, and the court may award reasonable attorney's fees and costs to the party as opposed to shall. This would apply to claims for relief or defenses after the date of the law in a situation where a city or county has done something for which they do not have legal authority. The citizen has the challenge to assert their rights. Okay, this originated was actually a citizen request to me where they were, there was action being enforced against them or proposed, which the city had no right to do, and in fact, it used the same defense in a lawsuit of theirs that they were now rejecting on the part of the citizen. And in talking to several people, I discovered that there's a frequent situation that arises where someone talks to an attorney and says, can they do this? And the attorney says, no, they can't, but it'll cost you more to fight it than it will to just do what they want. So this allows the citizen in that case, where it's in the opinion of their counsel, it's clear the city doesn't have the authority to do what they're doing, or particularly the city employee doesn't have the authority to do what they're doing, to actually take on an action to defend it and protect their rights.
Thank you, Mr. Chairman. I'm in favor of the bill. I've sued a lot of governments, and so I like the attorney's fees provision, particularly the ones I've used in civil rights cases. I'd like to ask, though, the bill sponsor why he changed the bill. I'm in support of the bill in both situations, but I think the PCS will have the issue raised more frequently, but attorney's fees potentially denied more often. And that the original bill would have the issue raised less frequently. It would be a very narrow class of cases where you could ask for the attorney's fees, but you would be guaranteed because they would be the most egregious case. And so I'm wondering why you would want to open it up to things that aren't so egregious, but make it so discretionary that even in the egregious cases you might not get attorney's fees, rather than just focus on the egregious cases and guarantee the attorney's fees. Because the original bill talked about no statutory authority and an abuse of authority, which means you have to prove both, which is a lot, and then you get the fees. In this situation, in the PCS, it's outside the scope of authority, which is a much more broader class of actions. But then you give complete discretion to the judge, and I think that probably you'll be denied the attorney's fees in lots of different situations. So please explain why you went from the narrower mandatory one to the broader permissive one.
I received a lot of counsel from people who are in fact attorneys, which I'm not, and also I learned that there's a certain amount of compromise that one does to move a bill forward. Now, if you would like to make an amendment to the bill to put shall back in or something like that, I would certainly appreciate the support of Representative Ross. As a freshman, I have learned that what I think I can do and what I sometimes actually can do may not be the same thing. But I certainly appreciate your counsel because you have demonstrated yourself to be a very effective advocate for the causes in which you believe.
Mr. Chairman.
Representative Ross.
Well, I can't put shall in the current version, because it's a broader scope of types of lawsuits. I thought shall was very appropriate in the original version because it was narrow to this, it was a narrower scope of lawsuits. So I guess it's just the trade-off that the gentleman has made, and so I'll support the bill the way he's made that trade-off.
Further questions from the committee? Is there anyone from